forum, so we are prepared. And we have with us John Ohaga, Senior Counsel, who is the chair of the Sports Tribunal. We have Gladys Mburu, the chair of Standards Tribunal. And we have Mohammed Balala, who is the chair of the National Environment Tribunal. So those are the tribunals we'll be talking about today, and hopefully you will learn a thing or two about these tribunals and make use of them. They are there for you. So before I invite our speakers to tell us a bit about their tribunals, I'd like to remind the participants, feel free to use the chat section to ask any questions that you may have about these three tribunals. We will have a plenary after the presentations, whereby we will address your questions and ensure that by the time you leave here, you have an answer. So just remember, you can type in your questions in the chat section and we shall read them out later. So let's get right into the business that brought us here today. We have the Sports Tribunal. I'll start with Senior Counsel John Ohaga. Many of us only hear about the Sports Tribunal when it comes to FKF, Gor Mahia and AFC, sometimes when it comes to Kenya and doping. So the question I would pose to you is, what is this tribunal about? Can I bring my badminton case there, or is it only for Gor Mahia and AFC?
Thank you very much, Helen. That's an interesting question. Let me, without answering your question directly, say that actually, as chair of the Sports Tribunal, I myself have learned a lot about the different sports that we have in this country. Did you know that there is a sport called Kabaddi? There's a sport called Kabaddi. And we presently have a dispute relating to that sport. I never in my wildest imagination thought there was such a sport. So the point is, we deal with every manner of sport. The tribunal's jurisdiction is as set out in the Sports Act at section 58. Just very widely, let me say the tribunal deals with sports-related disputes. There are disciplinary issues which arise. There is team selection issues which arise. We have had occasion to deal with employment type related disputes because, you know, sports employs people as well, teams employ people. In addition to just sports related disputes, the Sports Tribunal also has jurisdiction under the Anti-Doping Act to deal with offenses relating to doping, both for national and international athletes. There have been some amendments to the Act recently. But the other interesting facet is that, as you know, or as I would hope you all know, every World Sporting Federation discourages, in fact prohibits, their various federations and players from taking their sports disputes to normal courts. And so the Sports Disputes Tribunal therefore offers a forum for them to agitate their disputes. And most of those disputes, most appeals from our decisions would then end up at the Court of Appeal for Arbitration for Sport, rather than at the High Court. The High Court has no appellate jurisdiction. However, you can go to the High Court on a JR. You can go for judicial review if you think that the Sports Tribunal has in some way breached the administrative rules with respect to natural justice, or with respect to the discretion it has exercised, the way it has approached the matter, and so on and so forth. But you will find that they are constrained by your federation's rules and by your contracts and whatever arrangement you enter into from taking your dispute to a normal court. So all of these end up in the Sports Tribunal. As a matter of fact, I have 2 certificates of urgency waiting for me to deal with this afternoon, relating to something which is quite current in the sports pages already. So very broadly, that's what we deal with, Helen.
Wow, that's interesting. I actually did not know about being prohibited from taking a sports dispute to a normal court. We learn something every day. But before I move on to the next speaker, maybe you can tell us, what is Kabaddi?
Kabaddi, as I have recently learned, is a sport which is very popular in India. But very funny, in India, there is Kabaddi, which is played in the north of India, and there's Kabaddi, which is played in the south of India. And they have very subtle differences in their rules. And the dispute presently before the tribunal relates to one sporting organization, let me call it that, which is affiliated with the north of India form of Kabaddi, and the other one with the south of India form. It is, from my reading of it, is a sport almost like handball, handball. But it is extremely popular in Asia. It has spread from India into Pakistan, into Sri Lanka, and all those parts. And it's interesting. I would like one day to go and watch a Kabaddi match. I have to confess, I have not actually watched it in action, but just listening to the parties, I've learned quite a lot about it. Kabaddi.
Thank you. So my take from this is that it's possible for us to spread Kati and Blada throughout the continent. It becomes a popular game as well. So I'm going to move on to Ms. Mburu. I think your tribunal is the one amongst the 3 we have today that we know the least about. What is the Standards Tribunal?
Thank you, Helen. Really for the opportunity to tell you about Standards Tribunal. Standards Tribunal is established under Standards Act. This is the act that governs KEBS. So all our disputes come from KEBS. Our disputes are from KEBS. Now, how this tribunal was established was because under the Ministry of Industrialization, all the disputes arising from licensing, goods being destroyed, conformity, they all ended up at the minister's desk, as they were then called. And it was realized it was taking a lot of his time. It was getting messages dealing with all these disputes, and they decided under the ministry to just establish just kind of a quasi-judicial body to deal with all these disputes. And so all our disputes relate to KEBS. These are matters of licensing, conformity, standards, and just destruction of goods. Now, we were established to just make work easier in this ministry. And our composition, we are 5 members and a secretary. There's a chair who is supposed to be a lawyer, an advocate of 10 years experience, and the other members can be lawyers, they can be members of public, they can be a person who is familiar with standards. And our mandate really and function is to deal with all these issues when somebody, generally people will come to us and say, oh, KEBS has shifted the goalposts. They are now asking me for other things, mostly these people of SMEs, and they'll come to us and say, this is not fair. Then KEBS will be brought to us and we will deal with the matter. And generally, the matters that come to us are just matters that are easily dealt at that point, because we are people who have really been exposed to how KEBS work. Because the first thing we did as a board was to learn how KEBS operates. We understand the standards, we understand the testing, we understand where the goods are stored at the cost. So we get to know what goes on in this industry. And our powers under the Act is we can vary decisions by KEBS relating to licensing. We can confirm or we can set aside. and we can order goods to be destroyed or not to be destroyed. Filing of an appeal. People come to us, you can come in person, you can come with an advocate, you can be represented by a friend, and people file an appeal to a tribunal, and then we hear the matter. Our costs are really, really low because they vary from 2,000 to 200,000, depending on the subject matter. And then the filing for these other documents is usually between 50 shillings and 200. So they are very low cost. Timelines. We try to make timelines very short, but we try to literally make sure our matters are concluded within 4 months. All things constant. Sometimes we don't achieve that because of, changes here and there, but mostly, and really that's usually our goal in all our matters. We have our rules of procedure, and which are very, I would say, lenient. We are not overly tied up in terms of technicalities. We try to make it as easy as possible in view of the fact that sometimes people who show up at our tribunal want to represent themselves. And so we feel we need to make it easier for them. What else can I tell you about our tribunal? Our tribunal is based at South Sea, Kildy. We've been given space by Kildy. That is Popper Road. That's where our offices are. I guess that's all about the tribunal, unless somebody has something to ask later.
Thank you, Ms. Mburu. Now, from what I have heard, am I wrong to assume that in most cases, the respondent is KEBS?
Always KEBS.
Aha, okay. Right. Thank you very much. So let's move on to Mr. Balala, National Environment Tribunal. What exactly does your tribunal deal with? Am I going to be dealing with the guys who are pouring sewage or NEMA, or what kind of cases does your tribunal deal with?
Yeah, thank you very much, Helen. Well, our tribunal, first to just give a slight introduction, a brief introduction, is composed of 5 members. We have the vice chair. I'm the chairperson, and the vice chair is a lady, Madam Christian Kipsang. We have 3 other members with us, Bahati Mamuye, Weda Kangaruya, and Dr. Kariuki Mwigwa, as the composition of the tribunal. The tribunal itself has 6 slots, so you have 1 more slot, but that is at the discretion of the appointing authorities. Our quorum in the sittings are 3, so any 3 can hear and determine the matter, but we usually have a full bench hearing all matters, which is preferable. Now, the tribunal itself deals with environmental matters, but in a very limited way. We are formed by the Environmental Management and Coordination Act of 1999, and our jurisdiction flows strictly from Section 129 of that Act. So with respect to EMCA, which is the Environmental Management and Coordination Act, our jurisdiction is limited to the issues provided under Section 129(1) and 2. So Section 129 of EMCA essentially deals with licensing. All appeals from NEMA's licensing decision, whether to issue a license or to deny a license, comes to us. It includes very many things within the licensing regime, including variation of licensing, transfer of licensing, and any conditions, imposition of any terms and conditions within the license. So it's actually supposed to oversee the licensing powers of NEMA and supervise its conditions that it imposes. The other jurisdiction we have under Section 129 is an appeal from all decisions of the Director General. So anything the Director General of NEMA does, or his officers, or the committees of NEMA, which impact on the environment and someone is aggrieved, are brought to us. for determination. So if someone is aggrieved by the Director General's decision not to close a bar, for example, it's making too much noise, then you approach us. If someone is dumping rubbish outside your house in NEMA, you've written to NEMA and they're not doing something, you write to us. So it may affect one or two people, or it may affect an entire community. So it's got very wide powers, despite the limited boxing in under Section 129. The other jurisdiction we have and the other powers we enjoy is to give advisory opinions to the Director General and to the agencies of NEMA on certain important matters. So if they need to know something, they are basically allowed to ask, and we give an advisory opinion. That jurisdiction is rarely exercised because I think the agency itself is satisfied with the resource that they have. Once EMCA was incorporated in 1999 and the tribunal was formed in 2003, other statutes decided to use the tribunal as a way for disputes to be ventilated. And therefore, you will find that now under the Kenya Forest Services Act, the Forest Services and Conservation, the Kenya Forest Service decisions on certain matter are also referable to the tribunal for determination. And the other statute and other matters that we deal with is the question of wildlife compensation. So where there's wildlife compensation issues under that statute, then all appeals from the wildlife conservation and compensation committees are referred to the tribunal for determination as to whether the refusal to award compensation is fair and reasonable or not, and we make a determination on that. Those are the types of cases that NET, as we're popularly known, handle. One thing I have to clarify is that many people mistake NET or the tribunal to be a part of NEMA. So we are usually called the NEMA tribunal. That is absolutely not true. We are not an arm of NEMA, and we are in no way under the control of NEMA. In fact, our mandate is to hear disputes where NEMA is almost always a respondent. In many instances, NEMA come before us and they win matters, and in other instances, they lose matters. It is not a done deal that we are an internal arm of NEMA. We are not. Now, decisions of the tribunal are appealable to the High Court as of right, so that once a decision is rendered, then one has access to the High Court, to the ELC, in order to ventilate. And you will see from the decisions that have been rendered so far up to the Supreme Court in the Kibos matter, the Kibos sugar matter, the Supreme Court itself has rendered a decision on the jurisdiction of the tribunal to say that the tribunal is the first call for all environmental matters on licensing, so that anybody who has a dispute under Section 129(1) are obliged to first follow the steps provided by the Act and come to the tribunal. So that position has now been reinforced by the Supreme Court, in addition to the legal provisions that provide for that. How does one approach this tribunal? The tribunal is usually approached by filing an appeal. It's not very technical. It's a very simple document. There's a format for it. And even if a party does not follow the format, the tribunal is very liberal in allowing access to justice, as long as we're able to disclose the grounds of appeal and the prayers being sought. More often than not, that appeal will be admitted and will be heard. The rider is the appeals have to be filed within 60 days of a license or decision of NEMA. Once you are outside the 60-day period, then essentially you're locked out. The tribunal has no jurisdiction in that instance. So one has to be quite careful when approaching the tribunal. How does one file a case? We have our premises at Popo Road. This is in South Sea. where there's a registry that receives documents of appeal, and the filing fees is free. There's no filing fees. There's no charges for filing appeals to the National Environment Tribunal. Appeals are not only filed physically, but they also filed virtually through an email account provided by the tribunal. And pleadings are also filed both physically and virtually and exchanged virtually. All hearings at the tribunal are done virtually. For the last 2 years, we've been conducting proceedings, and all are done virtually, and has been seen to be quite effective. How of determinations be made on jurisdictional issues, especially for people who are filed outside the 60 days. And the ones that really extend do not extend beyond a year or a year and a half. So the tribunal itself tries as much as possible to determine disputes as quickly as possible. Of course, there are exceptional cases where we have gone beyond that timeline, but this is the norm. Does one need to be represented at the tribunal? No. The tribunal is open to members of the public, and we have a lot of litigants before us who are coming in person and are able to represent themselves well. And of course, where lawyers are participating, it makes things much easier as we're able to understand, as they're able to understand the procedures and things move forward. And a lot of lawyers practice before the tribunal. The tribunal itself is has a caseload that could be quite lucrative for lawyers, because the tribunal's mandate and its jurisdiction is not limited either nationally, geographically, or so that it has nationwide jurisdiction, and it has no pecuniary jurisdiction. So we are yet in the environmental matters. It would be very rare to find any case below a subject matter of 20 million, and sometimes extends to billions. So it could be quite a good place for practitioners to consider practicing, as your cases are had faster, the procedure is faster, and it deals with a lot of matters with substantial values of subject matters. The rules of procedure are, they were crafted in 2003. They're called the National Environment Tribunal Procedure Rules. They are currently under amendment, but those are the rules that we follow. Notwithstanding that, the tribunal is empowered to basically dictate its own procedure. So we stick to the procedure provided there. Where there's any lacuna, of course, the tribunal tries to meet and place some content on that gap. So that is a basic overview of what our tribunal does. And if there are any questions, I'll be more than happy to answer them. Thank you very much, Helen.
Thank you, Mr. Balala. I think we've had some good things there. First of all, for practitioners, that 20 million figure is not too bad. So I think practitioners here would be eager to practice before your tribunal. And even better was the fact that there's a vacancy. Yes, we had that. There's a vacancy in your tribunal. So I think job seekers will soon be sending in their applications. But let me circle back to something you said. So if your tribunal is basically, I start somewhere and then I file an appeal with your tribunal, and then from there an appeal to the High Court, right?
Yes, correct.
So in essence, this gives me a better chance or more opportunity in terms of appeals, isn't it? As opposed to if I went straight to the High Court.
Absolutely. And based on the Supreme Court's decision in Kibo Sugar, I think most of the High Court, most of the persons filing cases at the High Court, the ELC, are being referred back to the tribunal. Because in the Kibo Sugar matter, a person initiated his action at the ELC. It was dismissed, it went to the Court of Appeal, it was dismissed, and it was affirmed at the Supreme Court. that the starting point for all matters under Section 129 of MCA have to start at the tribunal level. So you save a lot of time by coming to the tribunal. The only caveat is that you have to do so within the time prescribed. And if you miss the 60 days, then we have no jurisdiction. Then you can access the courts through the ELC. Primarily with environmental justice, access to justice is a fundamental pillar. So, of course, the tribunal tries to meet that requirement and that pillar by providing access to justice. And if someone misses the boat, then they still have recourse to the ELC.
Great. So my next question goes to all three chairs. And one concern that members of the public usually have, particularly here where you have said they can represent themselves, they don't have to be represented by advocates, is that, you know, they walk into a court or a tribunal, it's quite intimidating. We see lawyers wearing these white wigs and their robes, and they look all serious. So, and then you're sitting there, maybe it's a judge who looks very stern, and you just feel like if I say the wrong thing, I'm going to be put in for contempt. So I'm going to start with the lady now, Ms. Mboro. Tell us, in your tribunal, is it all lawyers? Are there non-lawyers who sit there as members of the tribunal? And if there are non-lawyers, what exactly do they do? Can we feel at home at your tribunal? Sorry, you're muted.
Sorry about that. Yes, my tribunal, the members are lawyers. The secretary is also a lawyer. So really, it's really a legal show. But I can tell you that we try to make it as informal as possible in terms of just making the members of public feel they're free. We try to also encourage them to speak in Swahili if that's what they are comfortable with. Like what we do to make people comfortable when we go into a sitting, we all introduce ourselves. And generally, because we don't have very many people at any one sitting, we let everybody introduce themselves by their name or what they want to be called during the proceeding. And that kind of breaks the ice, and somebody feels like they've been seen in that tribunal. And we really do try to make it as informal as possible. We don't want them to feel like they're in court. And we also, fortunately for us, these parties we deal with need each other all the time, because if it's licensing, they are yearly, so they'll be back to KEBS after 1 year. So we try to make it as non-adversarial as possible, try to just get middle ground where a member of public leaves feeling they can always come back and get justice and get heard at the tribunal.
And how many members are at the tribunal?
5. We are 5 members, 1 chair and 4 members. Quorum is 3.
Okay, thank you. Senior counsel, you know, now that we hear your senior counsel, we now know that for sure we shall be hearing things like amicus, res judicata in that tribunal. Is that the case?
Well, I mean, in any decision-making body, considering matters of law, you will hear those. But in the Sports Tribunal, the makeup is of the membership of the tribunal is, of course, set out in statute. And it is a mix of legally trained persons and persons with experience in sports. So the act is very clear. The chairperson must, of course, have the qualification to be a judge of the High Court. Thereafter, there's a requirement to have a certain number of members who are lawyers, but who also have a sports background. And then there's another tier of persons who are not lawyers, but who have experience in sports. So we've got a very rich mix, and that really helps us to be able to interact with the sports people that appear before us, the federations. It also enables us to have sometimes a greater insight into the disputes, the nature of disputes. In many cases, actually more insight than the disputants think that we do have. which enables us then to really get to the root of the matter and try to resolve the disputes effectively, efficaciously. We really do try to ensure that there is not too much legality in the way that we approach the determination of disputes. We try to ensure that our proceedings are conducted in a non-threatening environment, in an environment that anybody can feel comfortable in. With respect to doping disputes in particular, our experience at the beginning was that a lot of the athletes who came before us charged with doping offenses were relatively young athletes, very naive in many respects, and therefore quite unable to articulate their positions and their defenses before the tribunal in any coherent manner. And you will know doping is also a strict liability offense, and the sanctions are very, very stiff. So what we have done there with doping disputes is to set up a pro bono list of advocates, because we also realize that there's very little knowledge within the legal fraternity relating to doping. So in order to open up the learning of jurisprudence around doping, we thought that if we invite people to list on our pro bono list and allocate athletes and cases to them, then they would have the opportunity also to learn something about doping. And we've been very fortunate. We've got a lot of people who have expressed an interest in joining the list. And so every doping case that comes before us, once we recognize that the athlete has a disability in the sense of an inability to represent themselves effectively, the first thing we will ask them is whether they would like legal representation. We will then put them in touch. The Secretariat will allocate a pro bono lawyer to them, who will then take instructions and will come back and represent the athletes. So we've tried to, in that way, facilitate access to justice, facilitate access to proper, competent representation, and ensure that the athletes that come before us charged with doping offenses have the best possible opportunity to at least try to fend off those offenses. Because, you know, when you look at an athlete's lifespan and you look at the sanctions imposed, they are very debilitating from the perspective of the career of an athlete. And we would like to try and do the best that we can to ensure that they can preserve their careers and that they can go on to compete effectively. I mean, just a case in point, for instance, and sometimes you can't take yourself away from the emotion of these things. Ferdinand Omanyala, whom you've seen represented Kenya very well in the 100 meters, had previously come before the tribunal just to be allowed to compete in the trials, because he had been charged with a doping offense 4 or so years ago. We had imposed a sanction on him. I think it was a 2-year sanction. He had served the sanction and completed his sanction, but the federation responsible for athletics had put in place a rule that any athlete who had been charged with a doping offense could no longer represent the country. So notwithstanding the fact that he had completed serving the sanction, he was going to be shut out from actually from competing. And I remember very clearly in my mind, I was away attending a retreat in Kisumu when this urgent application came in from the athlete on a Friday or on a Thursday, asking to be allowed to attend the trials at Kasarani on the Saturday, because he had been barred from attending those trials. And I issued an ex parte order requiring Athletics Kenya to allow him to compete at the trials. Subsequently, it came up, of course, inter partes, and we confirmed the order. And that opened the doorway for him to compete. He won the trials. He still had other hurdles to go, to overcome. And there's some lawyers who are very committed to the sporting course. And I remember he was represented by Ms. Sarah Ochwada, who some of you may know. That's really, we opened the gateway for him to be able to represent Kenya at the Olympics and to be able to break the records that he has done. So it is the ability to respond as quickly as possible. That's what we try to do, and to be as open as possible in recognizing what athletes need in order to be able to compete, the environment that they require, the strictures that stand in their way. And for that, the mix of professionals that we have who have both a sporting background as well as a legal background enables us to be able to make those decisions in a manner, I think, which serves the sports industry.
Thank you. So how many members are there in total?
So we have a total of 8 members. 8 members, 4 members with legal training and 4 members who are not lawyers, but who have experience in sporting matters. I try to ensure that when we constitute panels to hear matters, that we have a good mix of some lawyers and some sports people, because of course, being able to write a decision requires legal input as well. The coherence to be able to just articulate the arguments and set them out, structure it properly. But also you require the input of the people with sporting knowledge, who then advise relating to whether it's administrative matters, whether it is where Kenya has come from historically in its sporting journey, how federations work, how international federations work. Because if you don't understand, for instance, what is the closing date for entries for the Olympics? I mean, I can't issue an order today allowing somebody to participate in the Olympics because it would be futile. So you do need somebody with the knowledge to advise you and say, incidentally, admissions might have closed by this date, so we have to find another relief. And this becomes very important, especially when we've dealt with the selection disputes. When we're approaching major competitions, there's always selection disputes. The manner in which federations choose athletes to represent the country. The Sports Act requires every federation to have a selection policy, which sets out very clearly the criteria for selection. But that has had to be achieved progressively because it was not always the case. Sometimes we've discovered it was who was willing to share their allowance with an official. Unfortunately, who was willing to sleep with an official. It's been a very murky journey, I have to confess. And so part of what we're really trying to do is to tidy up the sports environment by having an insight into the things that ail sports and making sure that we clean it up by our decision making and ensure that it is better governed and that athletes have a really competence-based opportunity to be able to compete for the country. And that is where the mix of lawyers and people with expertise in sports comes in.
Thank you. So I'm just going to ask this for a friend. Is the list of pro bono lawyers closed?
No. Like the categories of tort, it is never closed, will not be closed. We have a list also for sports matters as well, incidentally, for both doping and sports. And all you have to do is indicate what you're interested in. We've found that sports law was not very well developed in Kenya, and it is allowing the development of sports law because the tribunal provides a forum for people to interact with sports disputes and therefore begin to learn what sports disputes entail and some of the nuances that are really particular to sports. So the list is not closed and everybody is welcome to apply and we'll be happy to take you on. Thanks, Helen.
Thank you. So we've heard there's a vacancy in NET, there are job opportunities in Sports Tribunal. Standards, I'm assuming we can also come there and join some list or other. Let me remind participants, for those who are joining us, thank you very much. Please remember to type your questions in the chat section. We will have a Q&A session as soon as we're done with the presentations. So let me ask the three chairs, actually two chairs now, because one chair has already answered this question. National Environment Tribunal told us that if you are to approach the tribunal, you do so by filing an appeal. And even if you do not follow the form or the format, they will still listen to you. So Ms. Mburu, tell us, in the Standards Tribunal, how do I approach you? Do I fill in a form? Do I write a letter? Do I just walk in and tell you I have a problem with kids?
Yes, how you approach our tribunal is by filing an appeal. There's no standard form. And if somebody gets to our doorstep and they have no idea what to do, we have a clerk who is well experienced, and they will guide them. We really don't have a standard form, but we'll guide them on what they need to write down to bring to the tribunal.
Thank you. Senior counsel, yours sounds very complicated. Do I need to come with a whole suitcase of documents? How do I approach the Sports Tribunal?
We allow people to approach in any manner that allows us to be able to understand and appreciate what the nature of the complaint is. Obviously, our legal training structures us to think that you must approach by way of whether it's a petition or a statement of claim or a plaint. But we have found that especially when you're dealing with non-legally trained persons or persons acting in person, it's very difficult to shut them out because they have not approached you in a manner that you think properly meets legal structures or strictures. So we try to just be able to read what has been presented and flesh out what we think the complaint is. So it is really quite open. We have a set of rules that we have been trying to get gazetted for quite a while now. I think we will finally get them gazetted with the new Chief Justice. But in a sense, when I look back, it's probably a good thing that it has remained open without the stricture of rules, because when I look at the rules that were first formulated, if they had been applied in the way that they were structured, it would have shut out a lot of people and would also have limited the way in which we have been able to understand the nature of disputes within the sports fraternity and to fashion reliefs which then meet the ends of justice. For instance, the way in which we sometimes move from a dispute resolution in terms of rendering a decision to mediation. There's many disputes that we actually mediate, and conciliation as well. And sometimes it's just expert determination because I know how that sport runs or what relates to the regulations and so on. And you're then able to cut the parties' time short by just applying one of the other mechanisms. And that's because we've had a relatively free hand in fashioning reliefs.
Thank you. Now, one of the concerns that many litigants have is time. Cases drag on and on and on in court. We've heard from the Standards Tribunal that it takes about 4 months to conclude a matter, barring any extraneous circumstances. So now let me ask Chair Balala, how long does it take at NET? You're muted. Still muted.
Okay, is it better now?
Yes.
Audible, okay, good. So the time it takes, as I say, depends on the type of case that we're handling. As I said, we have a range of cases. Some may be seen as very personal, involving just one person or a few neighbors, and others involving the environment at large and wider communities, where matters are being determined, for example, at a preliminary point on points of jurisdiction, because we have a lot of arguments in jurisdiction. People missing the timeline by a few days, the 60-day timeline. Then you have instances where those rulings are delivered in, well, we have to give time for arguments and submissions, and you find those cases take between 3 to 6 months to determine, depending on the arguments and submissions being filed. Then there are others where they're quite straightforward, and those don't take that long. But with the more technical ones, they could take 1 year to 1.5 years. So that is the ordinary time that we're looking at, 12 months from the inception to the end of a matter. As I said, it's not set in stone, because where lawyers involved especially, every moment is a moment where you can result in delays, so that you have applications being filed, witnesses who are lined up, who are not present, adjournments are sought. So despite trying to manage the time, you find sometimes you basically get out of the 1 year, 1.5 years, and you find some matters may spill over. But that's an exception, it's not the rule. The rule is basically between 3 to 6 months up to 1 year, 1.5 years for determination of a matter. Now, the case management system within the tribunal is such that no matter is lying at the registry. There's nothing like SOG at the tribunal. So nothing is stood over generally. Every matter has a date, whether it's a mention date or a hearing date or a ruling date. Everything has a date, so it will come up one time or another. We sit 2 weeks in a month. That is the first week and the last week of a month. During that time, a cause list is prepared. That cause list is published and published in the Kenya law reports as well. And just on the question of publication, I may add, I know this is not the question you asked, Helen, is that the decisions of the tribunal are available in the Kenya law reports. We have been digitizing and trying to put them on and send them to the National Council, and we have actually done a good job in trying. The people at the NET Secretariat have been quite effective and efficient in getting decisions done and sent to KLR. So KLR have a lot of decisions by NET. So that is the general timelines that we're talking about in matters before the tribunal.
Thank you, Mr. Balala. Senior Counsel Ohaga. Generally speaking, how long would a matter take at the Sports Tribunal?
It depends on let me just say, it depends on the nature of the matter. We try to move matters forward as quickly as possible, but when matters are very contentious, they can take up to a year. And sometimes arising from the nature of the matter, you will find that there's multiple, in our experience, multiple actions relating to those matters. So sometimes what we try to do is to consolidate them so that we can hear them more efficiently. But I would say that 6 months for a matter that's relatively straightforward, and up to a year if the matter is like when we had to deal with the elections around the Football Federation. That took quite a long time, just because of the way that it panned out and the fact that sometimes you have 8, 9, 10 council involved because of the sheer number of parties who are interested in the matter. We, like Mr. Balala's tribunal, we do not have any SOG. We ensure that every matter has a date as well. But we go beyond that, because one of the things that we recognized is that sometimes you give parties an order or some form of relief, and then being able to effect it becomes difficult, just because of the mechanisms or because the other party is being obstructive. So what we have done is to introduce a mechanism by which, even after the decision has been rendered, the tribunal does not render itself functus. The tribunal literally supervises the implementation of the decision. So for instance, where we have found that federations had faulty selection criteria, we recognize that if we don't assist them to formulate a selection criteria that meets the standards required under the Act, we will have those disputes being repeated. And so what we then do is to require the federation to formulate a proper selection criteria. We give them time and we ask them to come back and show us the criteria. We will go through it with them and make sure that we are satisfied with it before we close the matter. And that relates to other like matters. So we're not just a tribunal that is happy to say orders are sprayed, or we've granted this relief and now we've put our pens down and we move on. We will supervise and we will ensure that it gets done.
Wow. Okay, so now let me come to the money questions, because I'm sure very many advocates and members of the public want to hear the money questions. I'll start with Ms. Mburu. What is the cost of filing at your tribunal? I know Mr. Balala told us at NET there are no charges. What is the cost of filing a matter at your tribunal?
Yes, there are charges at our tribunal, and it ranges from 2,000 shillings to 100,000 shillings, depending on the value of the subject matter. The filing of these other documents range from 50 shillings to 100.
Thank you. Senior Counsel Ohaga?
Yeah, I think we've sort of shocked the sporting fraternity now by introducing charges. For a long time, filing was free. We did not charge anything. That was because we hadn't formulated any the requisite sort of table that sets out what the charges should be. But with the e-filing system having come into place, e-filing requires some costs to be borne. And so now you must pay, I think, between 75 shillings and 300 shillings or something. I can't say off the top of my head that I know what the exact amounts are, but it really depends on the nature of the document that you're filing. I know, for instance, yesterday I saw that a party needed to collect a judgment, and previously where they would get this for free, now it is a certain number of copies of pages that you require. And it was quite a lengthy decision, and the amount came to probably about 1,000 shillings for the judgment. So there is now some costs to be paid. People have had a free ride for a while. Unfortunately, we're now measured also on the basis of how much it is that we're able to generate. So
thank you. Now, my next question, I am coming to the end of my questions very soon. In terms of the awards that the tribunals give, do you give monetary awards? And if so, what is the highest you have given? Because I'm sure that the advocates would be very interested in that figure. Let's start with Mr. Balala.
Thank you. No, the orders we make are orders essentially done to enhance sustainable development. And therefore, monetary compensation is not something people are coming, because of the very nature of our jurisdiction, people are not coming to the tribunal to ask for monetary compensation. But the subject matter of the matters before us are quantifiable, and they run in millions and in many instances, billions of shillings. We have had a number of cases. For example, where the matter is to stop the SGR, for example, running from Mombasa to Nairobi, and then SGR2, phase 2. Both were matters before our tribunal. Presently, we have the expressway before us, which is a multi-billion shilling. There's a public project, although that's a pending matter, which we cannot discuss at length. We had the Amo coal plant case before us, which also was running into a subject matter of almost 60, 70 billion shillings. So you find that the subject matter of the matters we're dealing with are astronomical. Many instances, they affect the public and the national interest. Others are private projects that also could be housing developments, there could be factories and industries, all with a lot of pressure, because many of these developments may have committed innocent parties who have put in money. Sometimes they are financiers who have financed. So the impact, the financial impact of the matters before us are quite high, and the stakes are extremely high. And that is why we say it is a matter of great interest for lawyers who are looking at subject matter values. Of course, not that the money will be awarded, but that that themselves, they have a guideline as to what is the amounts they've been fighting about when charging their clients or trying to recover costs.
I'm sure right now the lawyers are cracking their heads to calculate the legal fees on that. Huh? Ms. Mburu, do we get any monetary awards from your tribunal?
Unfortunately, no. We have no powers whatsoever. And well, it's unfortunate because sometimes we'll find for an appearance, and the most we can do is advise them to use our judgment and the high courts to pursue damages. Yeah,
okay.
that does not provide for us to have any pecuniary powers.
Okay. Senior Counsel Ohaga?
Most of the matters that come before us do not actually involve monetary claims, except matters which relate to employment of athletes by primarily football clubs and sometimes maybe rugby clubs. So the amounts are not that significant. In fact, sometimes when I read the pleadings in relation to the employment contracts that clubs enter into with their players, and I compare this with what you read about, you know, English Premier League, the German League, and so on, I feel sad, actually, that we haven't been able to develop our sporting environment to ensure that it remunerates our very talented sports people sufficiently, because the amounts and the frustration that they face is quite severe and it's saddening. And so the direct answer to your question is that only in those employment matters do we have monetary claims, and even then they would not be very significant from a fees perspective. But if you're truly interested in developing sport and the potential for sport that exists in this country, I think it's something that we really should be striving to ensure that we have a better environment and better framework. It just gives you an insight into why sports should have been part of what are those pillars that Jubilee came into the next new term with? Yeah.
Okay, so what I gather is that in the three tribunals, for lawyers, we're basically doing this for the name and for advancing our profession and our knowledge in various aspects of practice. So I'm going to ask two last questions. The first question I'm going to direct to Senior Counsel Lohaga, and this is because we have been told that conveniently the Standards Tribunal and the NET are in South Sea on Popo Road. So we don't need to go far. They are just neighbors there. Where do we find you, Senior Counsel Lohaga?
Today, you find me from your desk, but we are on the 24th floor in SSF building. That's where the secretariat and our hearing room is. We have been given space there because the Ministry of Sports has some space there, and we were able to secure some space there. So it is quite conveniently located. You just jump across from Milimani Courts across to an SSF building, and you will be there. But in the last year and a half, as you would no doubt expect, most of our hearings have been virtually. I think I'm proud to say that we were the first tribunal to hold virtual hearings, even before the Chief Justice decided that we should start to hold our hearings virtually. So in that sense, we try to be as innovative as possible to allow as much access to us as possible. And it's been an eye-opener actually with holding virtual hearings. I can tell you that when we were hearing the dispute around the election of president of the Football Federation, for instance, on many occasions we had at least 75 people logging in to listen, because there would be players, there would be journalists, there would be the contestants, and of course the lawyers and so on. So just what virtual hearings have been able to do in the sense of allowing participation in the decision-making forum is something that has opened my eyes to the possibility of the wider reach. The fact that sometimes when I'm hearing a matter, I can hear a chicken crowing in the background. I know that's Aluya preparing dinner in Webuye, but interested in the matter still, but still being able to reach the tribunal. So it's been an eye-opener, and I think I would commend that to the legal fraternity generally.
Thank you. I think maybe at one point in time I must have been that one with the chicken crowing in the back. Ms. Mburu, we've heard from Sports Tribunal and NET that they've gone virtual. How about standards? Do we need to come all the way to South Sea, especially with Mombasa Road as bad as it is?
Yes, Mombasa Road is a mess. We don't want you to come to Mombasa Road. With time, it became almost like people come to us through documents. We actually, even before COVID, had very few hearings. People generally just kept on filing documents, and it just became our way of dealing with the matters. We've not gone virtual. We have not had a chance to go virtual. We've still been hearing matters by way of documents. Right now, we have a hitch on Quora. We have members who are supposed to be gazetted, they were not. So that has also slowed us down for a bit.
Great, thank you. As I ask my last question, I just want to ask the three chairs, if you don't mind, sharing with us your email addresses in the chat section so that the participants are able to reach the tribunals. I see Chairman Balala has already shared. Thank you very much. So if we could ask Ms. Mburu to do so, and Senior Counsel. So my last question is directed to Mr. Balala and Ms. Mburu. And this is because Senior Counsel has told us, well, you have no choice but to file at the Sports Tribunal. You can't go to any other court. So Mr. Balala, just give us 2 reasons why we should come to NET and not anywhere else.
I think there's only one reason, and the most important reason, is that the law provides that, and I've mentioned that this has also been reaffirmed up to the Supreme Court, that the starting point for all disputes relating to licensing and decisions of the Director General of NEMA have to originate at the tribunal, provided that that appeal is filed within the time set by law. That is the short answer as to why it's important you start at the tribunal and not at the ELC. More often than not, when you file at the ELC, you will be faced by an objection on jurisdiction, and the ELC has, in many instances, stayed matters and referred them to the tribunal, or dismissed a matter and struck it out and said the parties should go back. So that then results in waste of time and maybe costs. For that reason, I think it's important, if a party is genuine and sincere in the prosecution of this matter, they file in the appropriate place, in this instance in the tribunal. As I said, we are not only, and I think I'll repeat that, not only related to the environment, but also with matters related to forestry and wildlife and conservation, which have separate timelines, different from the ones in EMCA. So with respect to forestry and with respect to wildlife conservation, they have different timelines, and someone has to pay attention to the different statutes when coming before us. Some people make the mistake of thinking it's the 60 days that applies even to those other matters. It is not. So someone has to carefully look and see that they don't fall foul of the timelines provided. But that is the basic reason why it's important people come before the tribunal and not to another court.
Thank you. Ms. Mburu?
Yeah, I think I would say that the tribunal is the most convenient place for matters regarding licensing, destruction of goods. Importantly, because of speed, some of these matters require to be dealt with speed. I mean, looking at a case where goods are being held at the port, KEBS is saying they have not met the standards. The person is supposed to either ship them back to the country of origin or have them destroyed, and they are insisting they have met the standard. The longer it takes for the goods to be in those storage, the more likely that they might end up actually being substandard, although initially they were not, because of all that. And then there's all that demurrage costs. So when you come to the tribunal being so specialized in these cases understands what is at stake. So they know this matter cannot go on for more than 4 months because goods could expire, demurrage costs are being incurred, the inconvenience of a trader who cannot put the goods on the shelves. So for me, that is important. Secondly, tribunal is easy in terms of technicalities don't tie us down. We just want to deliver justice swiftly, fast, in an affordable manner. It's also a place where having interacted with all the KEBS, which is the licensing authority, actually, they are very, 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 very respectful and very concerned about what is going on at the standards. Like, we do not have any enforcement mechanism at the standard, but you have no problem. We have never had any problem with KEBS obeying our orders. So for me, I think having tribunal as your first port of call is an advantage to your clients. And I believe most of you is not just about fees. It's really, or really not most of you, all of you. It's about clients and justice.
Thank you, Chairs. Now I want to take a few questions from the chat section. Just to remind our participants, if you have any questions, please type them out in the chat sections. We're now in the Q&A part of our webinar this afternoon. So the first question I see is to the Sports Tribunal, this is to Senior Counsel John Ahaga. Does the Sports Tribunal have jurisdiction of the criminal courts?
No. There is no jurisdiction to determine. Certainly, a lot of doping offenses have a criminal element to them. But the agency responsible for overseeing doping in Kenya, that's the Anti-Doping Agency of Kenya, will know which offenses to bring before the tribunal and which ones to take before the criminal courts. There is also, I have to say, internationally, a very interesting debate that's going on about whether to criminalize doping offenses. So the US has taken the view that it will criminalize. The rest of the world thinks that criminalizing doping offenses doesn't sit well with the whole ethos and spirit of sports. But that's in relation to athletes. There are other players who facilitate doping, sports personnel, support personnel, doctors, pharmacists, all those people. Those should be open to criminal prosecution, and ADAC knows what to do with them, but they belong in the criminal courts, not before the tribunal.
Thank you. Chairman Balala, this one I believe is yours. Is it possible to seek extension of time of the 60 days period within which to file an appeal at NET? Sorry, you're muted.
Sorry about that. Yes, I said the answer is yes and no. Yes, if you're filing an appeal under section 129.2, and no, if you're filing an appeal under section 129.1. Now, the difference in the two is this. Under section 129.1 is the licensing issues, grant and refusal of licenses, or variation of license or extension of license. There is no discretion to extend time beyond the 60 days in section 129.1. So if you have a licensing matter and 60 days have passed from the date of the license, then the tribunal has no jurisdiction to extend time after that. However, where the decision being appealed from is under section 129.2 of MCA, which deals with the decisions of the Director General. So the Director General, for example, has come and closed your premises for something, or has come and closed your factory or done something, or is refusing to do something, because under the law, refusal to do something is also a decision. Then the 60 days lapses, you are permitted for good cause to apply to us to extend time under section 129.2 and rule 7, read with rule 4 of the procedure rules, the tribunal has powers to extend time. So that is the difference in the two. Yes, we can under section 129.2, and no, we can't under section 129.1. Thank you.
So someone has to read carefully and know where they are filing. Okay.
Oh, exactly. Absolutely. They have to know what they are challenging.
Okay. So as we continue, participants, please remember to type out your questions in the chat section. We have just one more question. So if you have a burning question, please make sure you're typing it out right now. Otherwise, you will need to send an email to the respective tribunals to seek clarification. So there's a concern or question by Madam Warogio, which I believe has been responded to by 2 chairs. But just to add, Madam Warogio, I think it is typical for Kenyans also to have 2 phone numbers. And the reason is because one is always a backup. You never know when the court.go.ke is down. So your Gmail is your backup. Otherwise, we would have litigants complaining that they can't reach the tribunals. So the next question is to Sports Tribunal. To what extent can the Sports Tribunal entertain breach of employment contracts vis-a-vis the Employment and Labor Courts or the Cmcc court?
That's an interesting question, because it's a question which has often arisen before the tribunal when players or athletes have brought employment disputes before the tribunal for determination. As I said, actually all international sporting federations discourage athletes, federations from approaching normal courts. And so you will find that stricture applies also in relation to contracts entered into between a sportsman and a sports federation. So when you consider it in that context, then yes, I know that as lawyers, we immediately think, but the employment court has jurisdiction with respect to an employment matter. But this is an employment matter which is implied into the employment contract is the rules of the International Federation, because the Sports Federation is affiliated to an international federation. You cannot get registration as a sports federation in Kenya unless you show your affiliation to an international federation. So all sports globally are governed at the international level, so that all jurisprudence relating to sports globally are then intertwined, and which is why the Court of Arbitration for Sports is a specialist court for determination of sports disputes. And so that percolates down to tribunals such as the Sports Tribunal. The employment court will, of course, take jurisdiction if you go before the employment court and nobody brings this to the attention of a judge or magistrate sitting in the employment court. But strictly speaking, as a sports person, especially if you are, if the nature of your performance in sports has an international element to it, you would find yourself in trouble if you went to a normal court. So that's the reason, and that's the answer to the question.
Wow. Right. I don't see any other questions. So I'm assuming that our presenters this afternoon were quite exhaustive and comprehensive, and we understood everything they were talking about. With that said, I would like to invite our speakers this afternoon to give us just, parting shots so that we can go off and enjoy the weekend. And because we only have one lady, I'm going to start with Ms. Mburu.
Well, I want to go to Sports Tribunal. It's interesting. It looks like where things happen. It sounds like a very nice place to work. Senior counsel, if there's an opening, we could switch.
We can merge our tribunal.
I'd say thank you, Helen, for organizing this. I didn't have a forum to talk about my tribunal, and I think it's a very useful tribunal. And to have this forum to tell all of you about it, it's a privilege. I'm deeply honored to be here this afternoon. I wish you a great weekend. Please be careful. COVID is real. I just lost a close relative yesterday. Just stay safe, friends. We need you in this country, in this community. Yeah, you will have a great weekend.
Thank you, Ms. Mburu. Mr. Balala.
Yes, thank you very much. Just as a parting shot, I think I would encourage all the participants here to consider having greater practice in the Environment Tribunal and appearing before us. The simplicity of our procedures enables access to justice for you and your clients. I think you will find that things would move faster than in the normal courts, and it would help in the development of the environmental law and jurisprudence of our country when we have the able participants participation of the lawyers in this platform who would contribute to the development of that jurisprudence. I think we encourage as much as possible greater participation and access to our tribunal to assist us and to assist the tribunal as well as the country at large in achieving proper economic and environmental harmony. Thank you very much for that.
Thank you, Mr. Balala. And finally, Senior Counsel Ohaga.
Not about the tribunal specifically, but in every forum at which I speak about the Sports Tribunal, I always say that when you think about the things that excite passion in people, There is politics, religion, and sport. Those are the things that excite the most passion globally. When you think about politics, politics is necessarily partisan. There is always some partisanship, Kenyan politics, tribal, economic, and so on. When you think about religion, it is whether you subscribe to one or the other. But sports breaks down barriers. Sports enables us to reach across, to compete in the spirit of friendship, and to lead a healthy lifestyle. So I want to commend sports to everybody. You don't have to participate in sports through the Sports Tribunal, but you can come and I can give you permission to go and jog at Jeffries if you need it. Please find a way to participate in sports, to lead a healthy lifestyle in these COVID times. You know that the makeup of your body is part of your defense against COVID. And at the Sports Tribunal, we truly believe that subscribing to the wider tenets of sports is the way in which we should reach out to the sports fraternity and to mankind, and to be able to just find ways in which we can interact with each other, get to know each other better, and promote the friendship and the camaraderie that sport encourages. So that's how we look at it at the Sports Tribunal, not just in the sense of a platform for decision making, but one for relationships. Thank you.
Wow. So, ladies and gentlemen, I think I have learned something this afternoon. I don't know about you, but I have learned so much about sports that I think I should apply for the International Olympic Committee. Some things I didn't even know, like the game called Kabaddi. I have learned it today. I have learned that NET is not the member tribunal, and we should never refer to it as that. And I have learned about standards. You know, for a long time, we didn't know what standards you were referring to. Is it standard of life? Which standard are you referring to? But now we know that it is KEBS. So I think everybody here must have learned one thing or the other. I encourage you to reach out to these tribunals. You have been told standards and NET are found on Popo Road. So when you visit one, make sure you visit the neighbor next door. And on 24th floor of NSSF, you will find the Sports Tribunal. So anytime you're at Milimani, you can just jump over, go up the flight of stairs. If you're that fit, you have been encouraged to take up sports. That could be one sport, running up to the Sports Tribunal from the ground floor. You never know, it could become an Olympic sport as well. So try it. Reach out to them. They have sent you their email addresses. Please contact them. Practice in these tribunals. I know we are always complaining that, oh, there's no work, but now you have been told there's practice in the tribunals. And it is quite lucrative. If you had those figures that they were mentioning, I think in terms of legal fees, that is something that is exciting to the lawyers. If you need another reason why you need to practice in the tribunals, you have been told they are experts in their fields. And in some cases, it's a legal requirement, so you have no choice. They are faster, they are cheaper, they are simpler, they are friendlier. I'm sure you can tell from the faces of the chairs here. They are friendlier. They were all smiling this afternoon. And in case you need another motivation, guess what? Chairman Balala is speaking to us from Mombasa. So those of you who are stuck in the cold Nairobi, NET might be the place you want to be. So reach out to these tribunals, practice in these tribunals. And I invite you to join us on the 20th of August for our next session, where we shall have the Tax Appeal Tribunal, the Cooperative Tribunal, and yours truly, the HIV and AIDS Tribunal. So ladies and gentlemen, thank you so much for attending today. I want to especially thank our speakers this afternoon. Ms. Gladys Mburu had a very hectic afternoon, but made time for us today, so thank you. Mr. Balala, as you heard, could be resting on the beach right now, sipping some nice water. But he has made time for us. And Senior Counsel Lohaga just mentioned that he had a certificate of urgency that he needs to deal with. This could be one of those ones who are representing us at the next Olympic Games in 4 years. So we shall allow them to leave us. Thank you very much, ladies and gentlemen. Please make sure you're joining on the 20th of August. Asanteni, keep warm, keep safe. We need you. Nice weekend.
Thank you very much, Helen. Thank you. Nice weekend.